if in the view of the COC, the applicant cannot implement the plan, then the COC should not approve that plan. Therefore, this is the duty of the COC to see that it is feasible and viable, and RP has the duty to record the discussion of the minutes of the COC meeting, whether this plan or all the plans are feasible and viable. 38(3)(d). Resolution plan should have provisions for approvals required and the timelines for the same. And they should mention that if the CD belongs to any industry where some licenses or approvals are required, then they will take all the approvals or licenses within the timeline, within the given timeline, and they should provide the timelines in the resolution plan. Regulation 38(3)(e). The resolution plan should demonstrate that the resolution applicant has the capability to implement the resolution plan. This is almost similar to the what 38(3)(b), feasible, viable, and here COC has to see that the resolution applicant has the capability to implement the resolution plan. 38(1)(b), 1(b). A resolution plan shall include a statement giving details if the resolution applicant or any of its related party has failed to implement or contributed to the failure of the implementation of any other resolution plan approved by the adjudicating authority at any time in the past. So resolution applicant should give a statement in the resolution plan that resolution applicant or any of its related party has not failed to implement or contributed to the failure of the implementation of any resolution plan. This statement should be there in the resolution plan. Regulation 38(4) and 5. Supervising and implementation of the resolution plan by proposing to constitute a monitoring committee. So this 38(4), 38(5) is with respect to constitution of monitoring committee. Normally the RP is a chairperson of the monitoring committee, or any other IP can be the chairperson of the monitoring committee, or now as per the latest amendment, any other person can also be the chairperson of the monitoring committee. 31(4). All approvals necessary to be taken for implementation of resolution plan to be taken within 1 year from date of approval of Honorable NCLT. So 31(4) says that if any approvals, licenses are necessary for implement, all those approvals and licenses within 1 year from date of the approval of the resolution plan. Then we can discuss the regulation 38 measures for insolvency resolution of the corporate debtor for maximization of value of its asset, including but not limited to the following. How we can implement the resolution plan. This is the mode the resolution applicant want to implement the resolution plan. How they will take over the company, the corporate debtor, how they will come into the management of the corporate debtor, and how they will implement the resolution plan. The regulation 38 is with respect to the modes through which resolution applicant intend to implement the resolution plan. This is regulation 37. The resolution applicant may provide that they may transfer all or part of the assets of the corporate debtor to one or more persons. So I would invite any of the my colleagues, if they can share their experience on any of the modes through which their plan was implemented. So I have not seen any resolution plan wherein the transfer of all or part of the assets of the corporate debtor to one or more persons. Now this project-wise insolvency in the real estate sector has come, through which we can not will transfer the project of the CD to the resolution applicant. But I have not seen anything like the transfer of all or part of the assets. All the CD can transfer to the other CD, that is normal, but we have not seen the part of the asset of the CD to transfer to any other person. Sale of all or part of the assets, whether subject to any security interest or not. The substantial acquisition of shares of the CD, or merger or constellation of the CD with one or more persons. So we can acquire the shares of the CD. Normally in the resolution plan we mentioned that either we are diminishing these shares and we are allotting the new share capital to the nominees of the SRA, or we mentioned that we are transferring the shares, existing shares, in the name of the nominees of the SRA, or it can be done through merger or consolidation of the corporate with one or more persons. In the case of merger, the corporate can be merged with the entity of the SRA or the SRA if the SRA is a legal entity or the company. But here the question arises whether when the company will, this CD will merge with the new entity or the entity of the SRA, then whether the stamp duty will be applicable. We can mention in the resolution plan that the stamp duty can be waived. But when we go to the authorities for the registration of the land or anything immovable properties with the authority, with the revenue authority, then they always ask for the stamp duty. So if anyone has any experience with respect to the transfer of immovable property by way of merger, demerger. Okay, I don't think there is any experience of any colleague who is participating in this conference. Then we can do the uh, we can take over this corporate debtor by the cancellation or delisting of any shares of the CD if applicable. Satisfaction or modification of any security interest. Curing or waiving of any breach of the terms of any debt due to the from the corporate debtor. So we can ask for the haircuts from the financial creditors. It normally happens in the resolution plan. Reduction in the amount payable to the creditors. Extension of maturity date or change in interest or other terms of debt due from the corporate debtor. This is again the kind of a haircut. Amendment of the constitutional document of the corporate debtor. Issuance of security of the CD for cash property securities or in exchange of for claims or interest or other appropriate purpose. Change in portfolio of goods or services produced or rendered by the corporate debtor. Like the Ruchi Soya was taken over by the Patanjali, and Patanjali has changed the branding of the Ruchi Soya, and they are selling their products of the Ruchi Soya in the branding of the Patanjali. This is what is a change in the portfolio of the goods and services produced or rendered by the corporate debtor. Change in technology used by the corporate debtor. Then we can also go through this regulation 38, which is the measures, which are the mandatory conditions for the implementation of the resolution plan. Here we have to take care that the amount due to the operational creditors under the resolution plan shall be given a priority in payment over financial creditors and dissenting financial creditors. Dissenting financial creditors shall be paid in priority over the FC who voted in favor of the plan. Resolution shall include as to how it has deal with the interests of all the stakeholders, including financial creditors and the operational creditors of the CD. 1. Plan shall include A statement giving details if the resolution applicant or any of its related parties has failed to implement or contribute to the failure of the implementation of the any other resolution plan approved by the adjudicating authority at any time in the past. It all we have discussed, but I'm going through that because these are the mandatory conditions for the resolution plan. A resolution plan shall provide the term of the plan and its implementation schedule, the management and control of the business of the CD during its term, and the adequate means for supervising its implementation. A resolution plan shall demonstrate that it addresses the causes of default, it is feasible and viable, it has provision for its effective implementation, it has provision for the approvals required and the timelines for the same, and the resolution applicant has the capability to implement the resolution plan. This is all about the regulation 38, which are the mandatory conditions for the resolution plan. I'm taking 1 minute. Then before PRA, before submitting the resolution plan, has to satisfy himself that he is eligible to submit the resolution plan and he is complying with the terms of the RFRP. Therefore, he has to go through in detail the terms of the RFRP and his eligibility with respect to submission of the resolution plan. As I said, then he has to deeply analyze the information memorandum and the RFRP. What is the status of the CD? Like in the real estate sector, if the license of the CD for the land has been cancelled by the consent authority, then it will not be possible for a resolution applicant to implement the resolution plan unless he has the capacity to restore that land, restore the renew the licenses of that land.
Excuse me,
Therefore,
sir.
he has to analyze why after reading the complete information memorandum. Yes, sir.
Sir, I have a small question. Can I?
He has the capacity to implement the resolution plan. Yes, sir.
Sir, I
Yes,
have
sir.
a small question. Suppose COC has approved the resolution plan and IA has been filed before NCLT for approval of resolution plan.
Yes, sir.
In resolution plans, few of conditions or regulation are not met with. So NCLT will approve or reject it. COC has already approved.
NCLT has reject the resolution plan.
Although COC has approved.
Sorry, sir.
COC has
COC is
already
approved. Then we had filed the. Okay, then we filed the application with the NCLT.
right, sir. So NCLT will reject or approve it.
Sir, it is NCLT. We will discuss the role of the NCLT and the ANCLAT. NCLT cannot override the commercial wisdom of the COC,
Right.
but NCLT has the duty to see whether the resolution plan is compliant with respect to the provisions of the code, and if it satisfy himself that the this resolution plan is complying with the provisions of the code, then NCLT has to approve it.
Right.
Then PRA should see the timelines for the timelines of the process of invitation and submission of the resolution plan. He has to prepare himself. He has to do all the due diligence of the CD, and then he can make the resolution plan and submit on time. Therefore, he has to take care of the timelines as mentioned in the RFRP. Then he has to see for the effective implementation of the resolution plan whether any waivers or exemptions are required. Then if the PRA thinks that any waivers or exemptions are required, then he has to specifically mention all the waivers and the exemptions which are required for the effective implementation of the resolution plan. Then resolution plan can be revised only once as per new regulation 39(1)(a). Therefore, he has to very careful that his plan is complete in all respect, because he don't have the chance to revise the resolution plan again and again. He will get one chance only for the revision of the resolution plan, to examine that the resolution plan shall not contravene any of the provisions of the law for the time being in force. So he has to see that he is not the plan will not contravene any of the provisions of the law. So
Sir,
what are the mandatory conditions?
I
Yes,
want to
sir.
ask one question.
Yes, sir.
My question is that the CRP has been started against the corporate debtor. Corporate debtor has the two projects. One project has been established by the got established by the financial creditor, who is a main member in the COC, having the 47% voting share. Now they are saying to return back this project to them, and they want to withdraw their claim also. Whether it is possible under the law.
So there is a specific provision in the IBC, which is section 12A, which provides for the withdrawal of the resolution plan.
Withdrawal of
Withdrawal of the CRP, sorry.
CRP.
They
My
want to
question
withdraw
is
the
that
CRP. If
there is a two project. One project belongs
yes,
to the financial creditor, who is having the 47% voting share. Now they are saying you return back this project to him back, and they want to withdraw their claim also. So whether it is possible to do,
as
or
per
we
me,
can
I
allow
I
them.
not heard any precedent on this of any court that one project can be given back to the financial creditors. Either the whole CRP will be withdrawn,
Hmm.
or one now the this project wise
The problem is that
form G
if the
can
project
be
belongs to the
issued,
project belongs
but
to the financial creditor is
that will remain
90%
in the
complete. Sir, my question is that the project belongs to the financial creditor, who is a member of the COC, is complete more than 90%. But the project to the others home buyers is not complete. है ना? And certain work is to be done by the financial creditor under the agreement. They have to install the electricity, they have to install the issue the TDR certificate and other and the financial creditor will complete the road also of the project. This work is to be done by the financial creditor, but they want their project, remaining project of them will be completed by them. They will withdraw their claim also,
I think, sir,
and
it is
they
not
want to take
possible.
that.
It is not possible. Yes.
Hello.
No,
Well, they cannot withdraw their claim, or they can we can RP don't have the power to transfer the project to the financial creditor. But financial it is possible that a separate form G can be issued for that particular project, and they can be the PRA for that project.
yeah.
They can take over
Can be
by that
possible.
way.
It might be possible some other person may
Yes,
come and they can file the resolution plan for that project also. And
that is
financial sector want that project
possible.
should go to them for the
That
completion.
is possible. He has to bid, and yes, sir, that is possible. Any other person may also come.
No,
Then
but
he has
problem
to
is
bid.
that no, sir. My question. Please understand my question. Ki under the agreement, this project was complete. This project was to be completed because that road is to be made by that financial creditor. The person who will come will not complete the road. Road will take, and he has to install the electricity. Electricity will also require the more than 3 to 4 crore rupees. So no financial other person PRA will complete the project in that way. This work will
No,
be
no, no.
done by
But
the financial creditor because that it is under the agreement with the CD.
sir, may
So
I ask
that
some
work cannot be
questions?
done by any other person.
Sir, who is the city and
Eh?
how is it? See, there is a CIRP going on against a particular CD, correct? Corporate
Yes.
debtor. I'm just trying to understand the picture that, and then there is this particular creditor, financial creditor, who has 47% voting share.
Hmm.
So the CIRP has proceeded to a stage where the RFRP and everything has been issued, correct?
Hmm.
So in this situation, the financial creditor can submit this resolution application, resolution plan.
No, if he will submit the resolution plan, or suppose some other person will come in that place that he will complete the project. But the problem is that certain work is to be done by the financial creditor under the agreement with the CD, like the construction of the road, like the electricity is to be bring by the financial creditor, because the financial creditor is a person who is a development authority is there. So these work can be done by them under the agreement. So no other person will complete this work. This is a peculiar problem in that project.
No, I think it is a bit too late for them to do anything in that case.
Huh?
Because they have to withdraw that in that case. If the RFRP is sorry, the resolution plan is not approved, till that time they can withdraw. Then they have to go for 12A.
Who will withdraw the plan?
No. I'm saying then the application needs to be withdrawn.
No, why the application will be withdrawn? Because the other project is there. The other project is to be completed by the PRA.
No, I don't think that this is
There is a
possible.
two project, no sir. One project belongs to the
No, okay,
one
okay.
project belongs to the other home buyers. है ना?
No, but then COC can adapt to separate resolution plans also, no? One for one project and one for other project.
two resolution plan will be floated by us. Then the financial creditor want that this project should go to them. They will complete, and they have to invest extra money in bringing the electricity outside in completing the road also. But the person who will file the resolution plan will not do like this. Problem is that.
I think, in my opinion, the COC can take a decision to split that project, one project to one applicant and one project to other applicant. So in that case, there is a possibility that this particular FC can get this project that he wants.
Hello.
No, I think let us proceed with the presentation. Maybe we can discuss this later, if it is okay with you.
Hello. Hello.
Yeah, hello.
My slide is, I want to again ask.
Sir, your voice is very low.
हेलो
Very
अब आ रही
difficult
है
to.
अब ना अब आ रही है आवाज आ रही है
नहीं आ रही अभी.
अभी भी नहीं आ रही
और our
हेलो
no,
हेलो अब आई
it's little better.
अच्छा हेलो 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 हेलो
Yes, it is little better.
हेलो
Sir, may I suggest that maybe Mr. Singh can proceed with this presentation, and then we can take it up at the end of the session.
चलिए कोई बात
Yeah,
you can do it.
right. So, Ashish, yeah, maybe you can continue, in my opinion.
100% और कहाँ से बोलेंगे अरे निकोल
Mr. Ashish, have we lost Mr. Ashish?
Yes, sir. I'm
Yeah, I
audible.
think.
Yeah. Then sir, we have to keep in mind the various information details we have to give in the resolution plan along with the affidavit of the resolution applicant and all the connected persons, because the 29A says that the resolution applicant must be eligible along with their connected persons defined in section 29A. Therefore RP is duty is to take the affidavit under section 29A from the resolution applicant as well as from all the connected persons. Then RA should mention the specific source of funds that shall be used for the payment of the CRP process in priority to the repayment of any other debts of the company to the satisfaction of the COC. Then the terms of the resolution plan and the implementation schedule he has to take care. Stipulate the mechanism regarding the management control of the affairs of the CD post the approval of the resolution plan by the adjudicating authority and post transfer date. Manner and of implementation and supervision of the proposed transaction. Declaration to the effect that the resolution plan is not in contravention of the provisions of the applicable laws. So these things, RA has to take care while drafting the resolution plan. then he has to see that all condition under section 30 of the IBC and the regulation 38 of the CRP regulation are satisfied to that effect. Obtain the necessary approvals required under any law for the timing force within a period of 1 year. He has to mention this thing from the date of approval of the resolution plan by the adjudicating authority. I had seen in my some cases that in the real estate companies, they have to take some licenses approvals from the concerned authorities who issued the licenses. So they say that in the definition clause they had given the definition of the effective date. They define the effective date as the date when we will get all the approvals and licenses for the implementation of resolution plan, and the tenure of the mentioned in the resolution plan will commence from the date of the effective date. I've seen many resolution plans like this. So this all approvals we need to take within period of 1 year. It should be specifically mentioned in the resolution plan. A resolution plan conforms to the requirements as specified by the IBBI. Applicant shall, in accordance with the IBC and the CRP regulations, in particular regulation 38 thereof, provide in the plan all such details in the resolution plan, including but not limited to those mentioned in the RFRP document, which shall be required to assess the viability and feasibility of the plan by the committee of creditors. These are the mandatory contents for the resolution plan. We should take care while drafting the resolution plan. Now, briefly, we'll discuss the 29A. The resolution applicant should be eligible under section 29A. So 29A small a is that he should not be undischarged insolvent. He should not be a willful defaulter in accordance with the guidelines of the RBI issued under the Banking Regulation Act 1949. Then at the time of submission of the resolution plan, has an account or an account of the CD under the management and control of such persons or of whom such person is a promoter, classified as a non-performing asset and in accordance with the guidelines of the RBI issued under the Banking Regulation Act 1949 or the guidelines of the financial sector regulator issued under any law for the time being in force, and at least a period of 1 year has left from the date of such classification till the date of the commencement of the CRP of the corporate debtor. In one of my cases, sir, the applicant was the NBFC company, and issue was raised that this NBFC company, this applicant is the related party or is not complying with provision of section 29A under regulation 29AC. Then the question arises, what was the NPA date? Because in the NBFC company, normally NBFC company, there is no guidelines with respect to the declaration of the NPA of the assets. So on that basis, because the order was something, but this was the issue in the case of the NBFC company, because NBFC company normally don't issues the date of the NPA, classification of the asset as a NPA. Provided that the person shall be eligible to submit the resolution plan if any such person makes payment of all overdue amount with interest thereon and charges relating to non-performing asset account before submission of resolution plan. This we had seen in the SR Steel case, and this proviso has come from after that case only. Provided further that nothing in this clause shall apply to a resolution applicant where such applicant is a financial entity and is not a related party to the corporate debtor. If the entity, this applicant PRA is the financial entity like NBFC company, then this provision will not be applicable on that company or its related party who are doing these things in a normal course of ordinary course of business. Then 29AD. Has not been convicted for any offence punishable with imprisonment for 2 years or more under any act and especially under the 12th schedule or for 7 years or more under any other act for time being in force, provided that this clause shall not apply to a person after the expiry of period of 2 years from the date of his release from imprisonment, provided further that this clause shall not apply in relation to connected person referred to in clause 3rd of explanation 1. 29AE, he should not be disclosed to act as a director of the under the Companies Act 2013. 29AF, he should not be prohibited by the SEBI from trading in securities or assessing the securities market. 29AG, he has been a promoter or in the management or control of the CD in which a preferential transaction, undervalue transaction, extortionate credit transaction, or fraudulent transaction has taken place, and in respect of which an order has been made by the AA under this code. So if any avoidance application has been filed against any company and AA has passed order in that avoidance application, the management or their connected person will be ineligible to submit the resolution plan. Provided that this clause shall not apply if preferential transaction, undervalue transaction, extortionate credit transaction, or fraudulent transaction has taken place prior to the acquisition of the CD by the resolution applicant, pursuant to resolution plan approved by the court or pursuant to the scheme or plan approved by the financial sector regulator or a court, and such resolution applicant has not otherwise contributed to the preferential transaction, undervalue transaction, extortionate credit transaction, fraudulent transaction. 29AH, has executed a guarantee in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or in part. 29 means 29AC was with respect to the NPA, and 29AH is with respect to has given any guarantee which was not fulfilled by the applicant, because 29AC and 29AH has been exempted by 240A of the code if the company is the MSME is registered under MSME. 29AI is subject to any disability corresponding to clause A to H under any law in a jurisdiction outside India. 29AJ has a connected person not eligible under section A to I. This is all the ineligibilities to be a resolution applicant. Now we will discuss the basic contents of the resolution plan. What should be the basic contents of the resolution plan? There should be a definition and interpretation for the terms used in the resolution plan. Then the CD or RA should mention about themselves. They should mention about the company corporate debtor, and then they will give the overview of the resolution applicant. What is the profile of the resolution applicant? What is the net worth? What are the various projects they have done? Everything. Then credit worthiness and financial capability of the resolution applicant, that they can implement the resolution plan. Prior experience in managing turning around of the company, if they have done any successfully implemented the resolution plan, and they should mention that thing also. Credentials as required by regulation 38 of the CRP regulations, that regulation 38 we already discussed, that is a mandatory conditions that they are fulfilling all the conditions under regulation 38. Financial plan, settlement of all creditors, restructuring of the CD, classification of the creditors. They should mention specifically that how they are settling all the creditors, whether it is financial creditors, operational creditors, employees, or any other creditor, how they are settling all these creditors. Extinguishment of claims prior to CRP commencement date or NCLT approval date or date of upfront payment. They should mention that if any claims, and if there is any claim prior to the CRP period, that claim will not be entertained after the approval of the resolution plan. Relief, concessions, and dispensation if they want, for the proper implementation of the resolution plan. Cleanup actions table of content. Cleanup actions table of content of a resolution plan. Key terms for the implementation of the plan. Terms of the resolution plan and its implementation schedule. They should mention the tenure of the resolution plan for the implementing the resolution plan. And also they should mention that phase wise, that in this time period they will complete first phase of the resolution plan, and balance in these time phases they will complete the resolution plan. Mechanism regarding the management and control of the affairs of the company during the term. They should mention in that how they are taking the management control of the company. Manner of supervision and implementation of the plan. How they will supervise the plan. They should constitute the monitoring committee. So they can be members as per the code, as per the regulations. Declaration that the plan is not in contravention of the provisions of the applicable law. Statement as to how the resolution applicant has dealt with the interest of all the stakeholders, including financial creditors, operational creditors of the city, sources and identification of the fund to make the payment, table of content of a resolution plan, financial assumptions, projection, business plan of the company, a rationale for investment in the city, synergies, indemnity and miscellaneous items. These can be the basic contents of the resolution plan, but RA is free to make the contents of the resolution plan as per their wishes. There is no mandatory contents for the resolution plan. Then the resolution plan approval. As per regulation, as per section 30 of the code, the responsibility of approving a resolution plan rests with the committee of creditors, which will approve the resolution plan by not less than 66% voting in favor of it. Effect of the approval: if the adjudicating authority is satisfied that the resolution plan as approved by the COC under subsection 4 of section 30, it shall by order approve the resolution plan, which shall be binding and whom law on the city its employee members, creditors, including central government, any state government or any local authority to a debt in respect of the payment of dues arising any of the time being in force, such as authorities to whom statutory dues are owed, guarantors and other stakeholders involved in the resolution plan. Once the resolution plan is approved by the adjudicating authority, then honorable NCLT approval, after the approval, then it will be binding on all the stakeholders, including creditors, including government authorities, and including the state governments or central government. It will be applicable on all. Implementation of the resolution plan. To implement the plan, the IBC under Regulation 38(2) requires a resolution plan to clarify the following points. Timelines for the payment of the CRP cost, OC. It should be taken note of that it is mentioned in the regulation that the CRP cost should be paid in priority, but it is not mentioned that it will be paid immediately after the approval of the resolution plan. Applicant may say that they will pay the CRP cost after 1 year after the approval of the resolution plan, but it will be paid in the priority. Then payment to the OC, dissenting financial creditors. It is also important to note that it is mentioned that the payment to the OC or the dissenting financial creditor will be paid in priority, but it is not mentioned that it will be paid immediately after the approval of the resolution plan. I had seen in some resolution plans that the OCs or the dissenting financial creditors are paid just before payment to the other creditors. Like if they are making payment to the all the creditors, they are firstly making payment to the dissenting financial creditors, then they are making payment to the other creditors. But the times is same. Only thing is that firstly they are paying to the dissenting financial creditors. I think it is not complying with the law. It is in the compliance of the law, because in the law it says that they will be paid in priority. Getting clearance from under the Competition Commission Act, RBI in regard to the ECB and SEBI, depending on the circumstances. Control and management of the CD operations during its tenure. Then after the approval of the resolution plan, they had to take the control management of the CD. The time there must be mentioned the timing when they will be taking over uh, the shareholding of the company, or they will be allotting a fresh shares to themselves. It whether they are doing it after after some stages or immediately after the approval of resolution plan, but it must be after the payment to the uh, financial creditors or CRP expenses. Because when they are taking control and management of the CD, if some assets are secured, then they have to discharge the security from the financial creditors, and then they have to make payment to the financial creditors. Practically, when we are taking control of this corporate debtor, then we have firstly has to pay the discharge the security of the financial creditors. Then only we can take control of the CD. Adequate standards for supervising implementation of by the monitoring committee during the execution of
Sir,
the.
you want to say he has to make a payment first to the financial creditor for releasing the security of them.
No, I'm not saying that. I'm saying that I've seen in some cases practically when they want to take control, because the RP will give the control of the after the approval of the resolution plan. But normally the financial creditors make a
The
hindrances in
resolution
the.
plan has been approved, and whatever the contents of the resolution plan will have to be implemented. Okay, if the
Yes,
plan
sir.
says that he will make a payment of the financial creditor in the three intervals, and
It is as per the
when
it will be as per the terms of the resolution plan. But I've seen in some cases that the financial creditors like uh, don't discharges the assets unless their payment has been made as per the resolution plan. Means they theoretically the resolution applicant come into control of the corporate debtor immediately after the approval of the resolution plan, but there may be some hindrances from the financial creditor who has the security over those assets.
no
So
doubt about
complete
that,
control
but
of the CD can become only after the payment, or they can run the CD as per their whims only after the payment to the financial creditors. I'm saying in the practical point of view.
if he has mentioned that he will make the payment for 2 years, then the financial creditor have to honor the resolution
So
plan
they
that has
have
been
to honor,
approved
sir.
by the court.
They have to honor. Correct, sir. They
Yeah.
have to honor.
Yeah. Because the priority payment is only of the CRP cost, not of the other costs.
Correct, sir. Correct.
Other costs will be paid as per the resolution plan.
Right, sir.
Law is giving the protection only of the CRP cost. That is to be priority. Other things will be as per the plan.
Okay. Right, sir. And I'm agreeing with you. I'm saying on the practical point of view only. I've seen
Yes, yes, no doubt.
in some cases that the RA got some difficulties in taking control of the assets of the CD.
Yes.
Jurisdiction of the NCLT and CLAT. As some colleague has asked, what when the COC has approved the resolution plan, should the NCLT shall approve the resolution plan? The jurisdiction of the NCLT or the NCLAT is limited with judicial review. Limited judicial review available to the AA or the NCLAT, which has to be within the four corners of the section 30 subsection 2 and section 32 read with section 61(3) of the code respectively. Such a review can in no circumstances trespass upon a business decision of the majority of the COC. Ultimate discussion of what to pay and how much to pay each class or subclass of creditors is with the COC. But the decision of such committee must reflect the fact that it has taken into account maximizing the value of the assets of the CD and the fact that it has adequately balanced the interests of all the stakeholders, including the OCs. The reasons given by the COC while approving a resolution plan must thus be looked at by the A only from this point of view, and once it is satisfied that the COC has paid attention to these key features, it must pass the resolution plan, other things being equal. So NCLT has to approve the resolution plan once it is satisfied that it is within the four corners of the law. Then said what key points while drafting the resolution plan. First point is we should take care how this plan will aim to maximize the value of the CD assets. Only the resolution plan is structured to turn around the operations of the CD or to resolve its assets. Strictly speaking, a resolution plan is not a contract, rather it is a nature of an offer that a prospective resolution applicant extends to the COC. The prospective resolution applicant have complete flexibility to revise their offers and to negotiate with the COC. A prospective resolution applicant may contemplate various measures to maximizing the value of the assets of the CD in the resolution plan, which may include sale of all or part of the assets of the CD, whether subject to any security interest or not, transfer of all part of the assets of the CD to one or more person, restructuring of the CD by way of merger, amalgamation, demerger, satisfaction or modification of any security interest. Most resolution plans seek to provide capital structure related solutions, given that the equity value of the CD undergoing the CRP is significantly eroded and the debt levels are largely unsustainable. Some resolution plans offer a monetization strategy whereby value of the from the sale of the underlying asset is utilized to discharge the restructured debt of the CD. Given that the primary objective of the IBC is to continue the CD as a going concern, a capital structure related solution is certainly preferable to selling the underlying assets. If anyone wants to comment on this, then they may comment. Second point we have to take care is that what about the historical liability of the CD? What protection can a prospective resolution applicant seek against them? So generally, all the prospective resolution applicant receive the CD on a clean slate basis as contemplated under section 32A of the IBC. This principle has been affirmed by the Supreme Court in various judicial precedents. However, the interplay of the section 32A with certain criminal statutes such as the PMLA is yet to be settled. Accordingly, PRA should ensure that their due diligence is thorough and that sufficient protection are built into their resolution plan. It is also important for a resolution applicant to seek necessary reliefs, concessions that NCLT is entitled to grant. This could include exemptions from compliance under the Companies Act pursuant to the acquisition of the corporate debtor by a resolution applicant. In one of my companies, our last audited balance sheet is of 14-15, and the plan is before the Honorable NCLT. It may be approved very soon, and there are no books available by the suspended directors because they were in jail, and both were expired during the COVID time, and there are no books of the CD. Then how they will make the books of the CD? How they will comply with the provisions of the Company Act, like the filing of the annual balance sheets, etc. So this has to be seen. They will get exempted because they cannot make the balance sheet unless we can make the previous balance sheets. This problem may arise. The PRA may also seek, according to the prevailing judicial precedent for all matters arising out of the applicable laws and contract, a resolution applicant will be required to satisfy the requirements of law and context. For instance, for the termination of a contract, due process under the relevant contract and applicable law is required to be followed. However, a resolution applicant should note that the position of law on simpliciter termination of contract as part of an approved resolution plan is not fully settled. This is what about the historical liabilities. They have to specifically mention the waiver or exemption of all the historical liabilities. Can a resolution applicant withdraw a resolution plan? So CRP is a sacrosanct and a time-bound process. According to prevailing judicial precedent, there are many case laws which says that withdrawal of a COC approved resolution plan is not permitted. If a resolution plan is sought to be withdrawn or is not implemented, this will attract penalties and forfeiture of EMD and the performance equity that may have been submitted by the resolution applicant along with the resolution plan. The NCLT may also impose additional penalty upon the withdrawal or non-implementation of the resolution plan which is approved by the NCLT. Sir, if you have any question, we may discuss. Can individual and separate resolution plan be submitted for multiple assets of the CD? Now, as we discussed earlier, sir, now there is a clarification provided in Regulation 38 subsection 1, 36A subsection 1, which was effective from 15th February 2024. This clarification says that the resolution professional, after the approval of the committee, may invite a resolution plan for each real estate project or group of project of the CD. Now, this clarification is applicable only on the real estate companies. Now it says that the separate Form G can be issued for separate real estate projects, subject to the approval of the COC. So prior to the amendment, 16 September 2022, all PRA were required to submit a single resolution plan for the CD as a whole, inclusive of all assets of the CD. Currently, PRA may submit individual and separate resolution plan for one or more assets of the CD if such a resolution plan are invited by the resolution profession subject to the approval of the COC.
Hello.
Yes, sir.
My question is that what will be the position about the two separate model is there? So the COC will be the separate or one COC will do the work?
Your voice is not audible, sir. Your voice is not audible, sir.
Hello.
Yes, sir. Yes, sir, please.
Now it is on.
Yes.
My question is that what COC will be separate for the separate project, or the one COC will do the work for all the projects?
Sir, there is no provision in the code which says that there will be different COC for different projects. There is
The
only
question is that if one project has a different kind of the problem, different kind of the things, other project is a other kind of the problem. Some liability is of such nature that cannot be divided between two projects, like the FDR holders. FDR holder has given the money to the CD. In this project, these FDR holders liability will go. Income tax liability or GST liability, where these liability will go.
Sir, now if there is no segregation of accounts of the projects of the city or the assets of the city, then it will be the duty of the RP to segregate the books of the projects or the assets of the city. He has to segregate the books of the city project wise. Then he has to mention it in the information memorandum. Accordingly, the resolution plan for the project can come. We have to do that, otherwise it will not be possible to give the resolution plan or we cannot issue the information memorandum for the project. We have to segregate because we cannot give the consolidated balance sheet for the company. We have to give the segregate balance sheet or the segregate books of account of the projects of the assets of the city.
You could write it.
Then sir, next question is a prospective resolution applicant required to submit details
Sir,
regarding? Yes sir.
I want one more question here. I
Yes.
want one more question.
Yes sir.
Suppose that the two forums has been published for the two projects. The resolution plan came for the one project and second project resolution plan does not come. In that situation, we have to complete the first project.
Sir, in
And
that
second will
situation,
remain unimplemented.
there is no precedent, sir. What I can anticipate is that if we issue the two Form G for two projects, if company has a two projects only,
Yes.
plan came, approved by the COC, and we filed with the NCLT. No plan came for the other project. Then
No plan came for other project. How that project will be dealt with?
then we have to file. As per me, because there is no legal precedent or there is no provision in the code. As per me, then we have to file liquidation application for the CD, because that project will remain the part of the CD. Liquidation application for the CD, and then ultimately it will be dissolved.
In that case, I have earlier told you. In that case, suppose the manager secretary is saying that he will this project to him.
Sir, your voice is not audible, sir.
आवाज ही नहीं आ रही। चलिए ठीक है सर, ओके।
सर वही मेरा है कि अभी बिकॉज क्लैरिटी इज नॉट देयर एज पर मी, तो जब तक आपका कुछ बचे रहेगा, इफ देयर इज सम प्रोजेक्ट इन द कंपनी और कंपनी, अगर देयर कैन बी सिचुएशन वेयर दे आर टू प्रोजेक्ट्स, we issued the two Form G, but in fact I think we have to issue three Form G, two for the project, one for the CD, because your transaction applications are agar ye or miscellaneous assets there may be in the company, we have to issue three Form G. अगर दो project आपका Form G आता है and it has been approved by the COC and NCLT approves it, then the CD will remain there. If some applicant came to take the CD, they can take away the CD and then the CD also resolved. If nobody comes to take the CD, then we have to file the liquidation application for the CD. Finally, this CD will be dissolved.
मेरा यहाँ पर ये कहना है, एक मेरी
इसके
प्रैक्टिकल प्रॉब्लम है, एक मेरी आवाज आ रही है सर आपको? मेरी प्रैक्टिकल प्रॉब्लम ये है,
अभी बेटर है। हाँ जी।
अच्छा, मेरा एक प्रॉब्लम ये है कि एक प्रोजेक्ट एक फाइनेंशियल क्रिएटर को बिलोंग करता है, वो कह रहा है कि ये प्रोजेक्ट आप मुझे दे दो, मैं इसे पूरा करूंगा, मेरा क्लेम खत्म कर दो। मान लो हमने दो अलग अलग फार्म जी निकाल दिए, एक प्रोजेक्ट का तो आ गया फार्म जी के अगेंस्ट में प्लान, और दूसरे में किसी का आया भी नहीं, और कोई आ भी जाएगा तो भी पूरा नहीं कर सकता, क्योंकि मैं सड़क और बिजली और सब उसी को लगानी है, फर्नीचर क्रिएटर को, जो प्लान से अलग है ना, उसका ही काम है करने का। अगर वो कोई लेगा तो वो कर ही नहीं सकता दूसरा आदमी काम। तो अगर मान लो कोई प्लान नहीं आता है और वो करना चाहता है तो उसे दे सकते हैं? नहीं दे सकते, क्योंकि नहीं तो कभी प्रोजेक्ट पूरा ही नहीं होगा, ये लिक्विडेशन में ले जाके भी पूरा नहीं होगा। दिक्कत ये मेरा यहाँ पर ये कहना।
सर इसमें और कोई देखो सॉल्यूशन तो लॉ में नहीं दिखाई देता मेरे को, क्या करना चाहिए, बिकॉज ये तो विड्रॉ आपका पूरी कंपनी के लिए होगा।
अच्छा, अगर हम ऐसा करते हैं कि हम आपके सीओसी अप्रूव कर देती है भी ये प्रोजेक्ट इन्हीं को देना है, और प्लान दोनों का निकालती है, और मान लो एसआरए जो है वो पीआरए जो है वो प्लान दोनों का देता है और कहता है भाई ये आपने पहले अप्रूव कर रखा है, इनको देना, दे सकते हैं ऐसे?
ऐसे दे नहीं सकते सर, बिकॉज सीओसी डोंट हैव द पावर टू सेल दी प्रोजेक्ट। सेल करने के लिए आपका प्लान ही आता है। अगर कंपनीज इनटू सीआरपी, सर यू विल अप्रिशिएट कि सीआरपी प्रोसेस में रेजोल्यूशन प्लान के अलावा आप कोई भी एसेट को किसी और को नहीं ट्रांसफर कर सकते हो, तो ऐसे आप ट्रांसफर कर सकते हो।
लिखा हुआ है, मतलब सी में लिखा हुआ है, मतलब सीओसी की मीटिंग में ये फर्नीचर क्रिएटर को जाएगा बाद में, इसका प्लान आप दे दीजिए और ये उसको देना होगा आपको, क्योंकि बिजली पानी सब उसी को लगाना।
सर वो फॉर्म जी आप इशू करोगे उसका और वो ले सकता है, एज ए बिकम आसारे बन सकता है उसका। यही ऑप्शन है और भी ऑप्शन नहीं है। और उसको लेना है तो दे कैन बिकम एसआरए, दे कैन गिव द रेजोल्यूशन प्लान, उस हिसाब से ही ले सकते हैं।
तो वो उसको दे सकता है, मतलब फाइनेंशियल क्रिएटर को अपने टर्म उस पे, है ना?
नहीं, अपने टर्म्स पे नहीं देगा, वो बिडिंग ही होगी नॉर्मली, बिकॉज ये आपका और भी कोई दूसरे पीआरएस भी आ सकते हैं,
नहीं वो तो आ
अगर उसका
सकते हैं, अब
सीओसी उनके
जो भी
कंट्रोल में है तो सीओसी ऑब्वियसली उनको ही अप्रूव कर देगा।
मेरा मतलब उनके पास अगर मान लो प्लान आ गया, उनका अप्रूव हो गया सीओसी में, उसमें ये लिखा हुआ है कि ये वाला प्रोजेक्ट जो है आपको फाइनेंशियल क्रेडिटर को देना होगा इनको, तो वो देने
वो
को तैयार
कंडीशन
है, सीओसी भी
सर,
तैयार है, तो कोई प्रॉब्लम नहीं होनी चाहिए ना।
सर अगर वो रिजोल्यूशन प्लान में ऐसा लिखा हुआ है कि वो प्रोजेक्ट आपको उनको देना पड़ेगा फाइनेंशियल
हाँ
क्रेडिटर्स को, तो वो कंडीशनल प्लान है। मैं कहता हूँ वो इम्प्लीमेंटेबल प्लान नहीं है, ऐसा क्लॉज नहीं हो सकता मेरे हिसाब से। बाकी एनसीएलटी डिसाइड करेगा, बट मेरे हिसाब से ये
ठीक है,
प्लान हो जाएगा फिर।
ठीक।
Next point is, sir, is a prospective resolution applicant required to submit their details regarding management and control of the CD in its resolution plan? So, given that the change in control of the management of the CD will affect the overall resolution, therefore, a resolution plan must provide for the proposed board of directors of the CD and the proposed key managerial personnel of the CD. It may include the CEO, CO, CFO अगर किसी को appoint करना है. This also helps in determining whether a specific resolution plan meets the relevant qualitative criteria under the evaluation matrix. तो I think डिटेल मैनेजमेंट का उनको हमें resolution plan में देना चाहिए. Next point is, how are amounts to be distributed to various creditors determined under a resolution plan? What happens to the dues of those financial creditors who do not vote in favor of the resolution plan? तो ये सर ये डिफरेंशियल ट्रीटमेंट ऑफ पेमेंट टू द डिफरेंशियल स्टेक होल्डर, ये क्वेश्चन कई बार हमेशा ही एनसीएलटी में आता रहता है. तो बट this is the sole wisdom of the COC to decide how to pay to which stakeholders. COC will decide this is the commercial wisdom of the COC. However, there are some laws on this. So the key aspect of the resolution plan is the financial proposal to settle the debts claims of various stakeholders. To the extent a resolution plan provides for a mandatory contents, inter se, distribution amongst the various stakeholders may be determined by the COC in the exercise of its commercial wisdom. Unless specifically prohibited under the RFRP, a resolution plan can be provided for the settlement of debts claimed by way of upfront or deferred payments. 32 small b second provides for the payment of debt of a financial creditor who do not vote in favor of the resolution plan in such manner as may be specified with the board, which shall not be less than the amount to be paid to such creditors in accordance with subsection 1 of section 53 in the event of liquidation of the CD. So there are some cases on this. In the matter of the Akash Ganga Processors Private Limited versus Shri Ravindra Kumar Goyal, Honorable Anclat Delhi bench deal with the situation where the successful resolution applicant made payment to selected operational creditors and did not make payment to other creditors of the same class, being operational creditors. This was set aside by the Honorable Appellate Tribunal on the ground that there cannot be any discrimination between the payment on one class of creditors. तो अगर आप डिस्क्रिमिनेशन करें, देयर शुड बी सम बेसिस ऑफ द डिस्क्रिमिनेशन. आप ऐसे ही किसी को 100 रुपए दे दे सेक्योर्ड फाइनेंशियल क्रेडिटर को, किसी को कुछ भी ना दे, ऐसे नहीं हो सकता. अगर कोई आप कम कर रहे हो, देयर कैन बी केस कि one secured financial creditor has the security of say 100 rupees asset, other secured financial creditor has the security of say 10 rupees asset. तो ऑब्वियसली जो आप 100 रुपीज सिक्योरिटी वाले को पेमेंट करोगे वो ज्यादा हो सकता है, तो उसका बेसिस है, तो उसको एनसीएलटी अप्रूव कर सकता है. बट विदाउट एनी बेसिस अगर आप डिस्क्रिमिनेशन कर रहे हो तो उसमें प्रॉब्लम आ सकती है. There is one more matter, sir, in the SBI versus Namdhari Food International Private Limited. The Honorable NCLT bench, New Delhi, has rejected a resolution plan on the ground that it was discriminatory. तो इसमें थोड़ा सा ऐसा था केस की इन दी there is a There is no dispute as to the fact that the NACL's claim has been admitted by the RP, but the resolution plan provides no payment at all to the NACL for the satisfaction of its claim, which is discriminatory against it as compared to the other operational creditors, given it a locus to challenge the resolution plan. RA, in its reply to NACL objection, has justified that no payment by stating that since liquidation value payable to NACL is zero, nil, thus no payment under the resolution plan is required to be provided. Further, the RA states that the payment is being made to the trade creditors but not being made to the related party trade creditors and non-operational creditors, such as NACL, because continuance of the CD without the support of the trade creditors will be impossible. But no such crippling harm shall accrue from the non-payment to the NACL or related party trade creditors. The contentions made by the RA do not stand in the light of the observation made by the Supreme Court. Supreme Court, in his observation, said that the resolution plan is discriminatory against NACL, thus deserves to be rejected as a on a standalone basis on this ground. Now, sir, अभी there is a very important case अभी आया है with respect to the Greater Noida Industrial Development Authority, Noida, versus Prabhjit Singh Soni, wherein the Supreme Court has passed a judgment which says that the Noida Authority is a secured creditor. तो उस बेसिस पे नोएडा के बहुत सारे प्लान्स में Noida Authority has filed their application. One of such cases is the Today's Home Noida Private Limited, when the principal bench has written back this resolution plan back to the COC Committee of Creditors for their approval that it is discriminatory against the Noida Authority. Being a secured creditor, they have to pay in accordance with the what other secured creditors the applicant are paying. So this is the latest case. Next point is, sir, resolution plan should not be conditional. तो ये कंडीशनल प्लान्स भी आते हैं, जैसे हमने अभी डिस्कस किया, सर कह रहे थे, तो इन माय ओपिनियन दैट कैन बी कंडीशनल. हम ऐसे कंडीशंस लगा नहीं सकते. तो वी कैन डिस्कस सम केसेस. कंडीशनल प्लान कैन बी लाइक,
sir, this is not a condition. This is not the resolution applicant is putting any condition. This is a direction is being issued by the COC to the resolution applicant that you have to give this project to the financial creditor whenever you will be successful for that. So you cannot say that this is a condition.
I'm not saying ठीक है सर. तो इसमें से कंडीशनल में कैसा एनीथिंग लाइक in the real estate, normally when the SRA takes the company, takes the corporate debtor, then normally the licenses for the construction of the project was cancelled by the concerned authority. और कई cases में the land was also cancelled by the concerned authority. जैसे नोएडा में Noida Authority gives the land on a leasehold basis. On non-payment of their lease rentals, Noida Authority cancels the this lease deed. So if in such situations, if the resolution applicant says that if he will be able to get the land restored from the Noida Authority, then only he will implement the resolution plan. And if he will not be able to restore the land from the Noida Authority, then he will not be liable, and his performance equity should not be forfeited. So I think this condition is conditional because he knows since the beginning that the land has been cancelled or there is no license on the license has been cancelled. Therefore, he should do his due diligence that he will be in a position to implement the resolution plan. He cannot say in the resolution plan that if he will not be able to get the licenses back or to restore the land, then he will not be liable. So there are some cases like in one of the cases, M2K Developers Private Limited versus Ramchandra D. Chaudhary, RP of the Anil Mega Food Park Private Limited. The Honorable NCLT Ahmedabad bench has dealt with a situation where the resolution plan was subject to certain conditions which the RP and the Committee of Creditors had to comply with. The relevant paragraphs are reproduced in below for the ease of reference.
So your slides are not moving actually. We see only one slide.
Oh, no, sir, yeah, I'm reading from my the thing.
Acha, okay.
Yeah, just yes, sir. The applicant said that there is no approachable road to the plan to the project. Therefore, if he will, this will be the responsibility of the committee of creditors to get him the approachable road. Then the NCLT has decided that it is not in dispute that due to the national highway in between the main road and unit of the CD, there exists no approach road. It is not possible for the RP and the COC to make available such an approach road leading to the unit of the CD which the resolution applicant is demanding through the resolution plan as approved by the COC. In our considered opinion, such resolution plan, if at all approved, cannot be effectively implemented by anyone. The proviso of section 31(1) does not permit us to approve such conditional resolution plan. So section 31(1) says that the plan should be implementable. If any condition is put in the resolution plan which makes the resolution plan non-implementable, then that condition cannot be will make the resolution plan non-implementable, and that cannot be approved by the COC. The next point is no room for the change, and the resolution plan is final. So you cannot change the resolution plan after the approval by the NCLT. So the modification of the withdrawal of the resolution plan under the IBC has always been a contentious subject with the NCLT and the UNCLAD taking conflicting views in the past. The issue was put to rest by the Honorable Supreme Court decision in the ABIC Singapore Private Limited versus Committee of Creditors of Educomp Solution Limited. The principle set out in the ABIC's judgment has recently been reiterated by the Honorable Supreme Court in the case of Shri Multiple Asset Investment Trust Vision India Fund versus Deccan Chronicle, Marketers and others. Honorable Supreme Court, while relying on this principle, held that once the resolution plan stands approved by the COC, no modification are permissible. It is either to be approved or disapproved, but any modification after approval of the resolution plan by the COC based on its commercial wisdom is not open for review by an adjudicating authority unless it is found to be contrary to the mandate of the IBC. Supreme Court has held that even a procedural technical change to a resolution plan would require prior approval of the COC. If, like in the real estate cases, some cases are 3 years old and more than 3 years old. The plan was given like 2 years back or 2.5 years back. Now situation has changed. COC wants to change the terms of the resolution plan. Then they may ask the resolution applicant to change the terms of the resolution plan. And if the COC approves the resolution plan, then the addendum to the resolution plan, because firstly the resolution plan was already approved. Then on the request of the COC, if the applicant changes the plan and it again approves by the COC, then the as per the Supreme Court judgment, NCLT may approve this amended resolution plan. Last point is a time-bound approval of a resolution plan, provisions and case laws. Regulation 40A of the CRP regulations provides a model timeline for the CRP. Accordingly to the table provided in the regulation, the timeline for submission of the COC approved resolution plan to the A is within 165 days from the commencement of CRP. So, in the matter of the Rico India Limited, RP on the authorization of the COC had accepted two resolution plan after the expiry of the deadline for submission. Finally, the resolution plan of the consortium of the Kalpras and Rekha Junjunwala, which was submitted after the deadline, was approved by the COC. So this is all about this all about the what the key points which we had to take care while drafting of the resolution plan. We can take 10 minutes break. If anyone has a question, they can ask a question. After that, we will take the 10 minutes break. So we are taking 10 minutes break. We'll resume at 3:50. Thank you, sir. So is it okay? We can take 10 minutes break?
Yes, sir. Fine, sir. Fine.
Yes, sir. Okay, sir. Thank you.
ये डॉक्टर राज सिंह आरडी जो है इनकी रिटायरमेंट कब की है देखा Hello. Yes, Ashna, how are you? I'm fine, dear. Tell me. I am in the middle of a webinar, which will last till 6 o'clock for you, 5:30, 6 o'clock. We have just taken an off for 5 minutes for tea break kind of thing. Yeah, yeah. This is regarding what? Okay. So we can around quarter to six, quarter to six, six. Yeah, yeah. Okay, okay.
Sir, can we restart?
Yes, sir.
So second part of this webinar is the negotiation while drafting the resolution plan. So negotiations can take place in the COC meeting only, and the RA has the right to participate in the meeting wherein his resolution plan is being discussed. So section 30 subsection 5 provides that the resolution applicant may attend the meeting of the COC in which the resolution plan of the applicant is to be considered. So resolution applicant gets a chance to explain the resolution plan to the members of the COC. So in one of the cases in the which is in the real estate company,
Uh,
applicant requested me. Yes, sir.
Sir, can you make it a full screen?
Yes, yes, sir. In one of my cases, sir, resolution applicant requested me in the real estate company to allow them to directly interact with the home buyers to explain them their plan. So because the home buyers cannot attend the COC meeting, so I checked with some of my RP friends. They also had allowed the home buyers for the direct interaction with the resolution applicant. So I also allowed them. So the resolution applicant can should have the chance to negotiate their resolution plan or to explain their resolution plan to the stakeholders, including the home buyers or to the COC. So COC members may negotiate with the resolution applicant regarding the terms of the resolution plan and may request for the modification of its term for the best interest of the stakeholders. So this negotiation can take place at the COC meeting only. So what we can negotiate? So there are some pointers which we will discuss for the negotiations. Now, number one is whether the resolution plan can provide for the extinguishment of unascertained, uncrystallized, future unknown contingent liabilities. The answer to this is this issue of whether a resolution plan under the IBC can provide for the extinguishment of unascertained, uncrystallized, future unknown, and contingent liabilities have been addressed in several key judicial decisions. The principle laid down by these judgments help clarify the treatment of such liabilities within the framework of the IBC. Some of the main cases with respect to this is the Committee of Creditors of SR Steel India Limited versus Satish Kumar Gupta. This was pronounced by the Honorable Supreme Court in 2019. The summary of this case is that Supreme Court emphasized the importance of the commercial wisdom of the Committee of Creditors in approving the resolution plan. The court held that the COC decision on how to deal with the liabilities of the CD, including contingent liabilities, are paramount as long as they are fair, reasonable, and comply with the provisions of the IBC. This case underscored that once a resolution plan is approved, it binds all the stakeholders, including those with the contingent claims. The impact of this decision is that this decision allows the extinguishment of contingent liabilities if the resolution plan is approved by the COC and subsequently by the adjudicating authority. So I would like to request all the participants here, if they have any queries, then we will take all the queries at the end of this negotiation part. They can write their queries in the chat box. So you can write your queries in the chat box. We will take all the queries at the end. Other important case law is Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited. This was decided by Honorable Supreme Court in 2021. So summary of this case is that court ruled that once a resolution plan is approved, all claims against the CD, including statutory dues and contingent liabilities, stand extinguished unless they are specifically provided for in the resolution plan. The judgment stressed that the aim of the IBC is to ensure that the resolution applicant has a clean slate to revive the business without being burdened by the past liabilities. The impact of this judgment is that this case further reinforced the principle that a resolution plan can extinguish contingent liabilities provided the plan is approved through a prescribed legal process. Another important case is the ArcelorMittal India Private Limited versus Satish Kumar Gupta and others, decided by the Honorable Supreme Court in 2018. Summary of this case is the court addressed the eligibility of the resolution applicant and scope of their plans in dealing with various types of liabilities, including contingent funds. The ruling clarified that the resolution plan should comprehensively deal with all the claims and liabilities of the CD to ensure a holistic revival. The impact of this decision is that this decision supports the inclusion of provisions in the resolution plan for dealing with contingent liabilities, affirming the COC discretion in such matters. So the various principles we get from these judicial decisions is that the COC has the discretion to decide the treatment of all the liabilities, including contingent ones, within the resolution plan. Courts have consistently upheld the primacy of the COC commercial wisdom. Then, clean slate for the resolution applicant. To encourage the potential investors and resolution applicant, IBC framework allows for the extinguishment of past liabilities, including contingent and uncrystallized claims, ensuring the CD can start afresh post-resolution. Then the other principle come out from these judgments are the binding nature of the approved resolution plan. Once a resolution plan is approved by the COC and the NCLT, it is binding on all the stakeholders, including those with contingent claims. This binding nature is crucial for the finality and certainty of the insolvency resolution process. It should ensure in the resolution plan that it has deal with all the claims, all the contingent liabilities very specifically, comprehensively, and addressing how various liabilities, including contingent ones, will be treated. The plan should outline the extent of extinguishment and the treatment of such claims to avoid future dispute. So we can conclude that based on the latest case laws, a resolution plan under the IBC can indeed provide for the extinguishment of unascertained, uncrystallized, future unknown, and contingent liabilities. Courts have, in plethora of judgments, held that the COC has the commercial wisdom in determining the treatment of these liabilities, provided the resolution plan is fair, reasonable, and complies with the provisions of the IBC. Approval of such plan by the NCLT further ensures their binding nature on all the stakeholders, thereby facilitating the revival of the CD without the burden of the past liabilities. These principles have been reiterated and clarified in landmark judgments such as we discussed in the SR Steel, Ghanshyam Mishra, and the ArcelorMittal, establishing a clear legal precedent for the treatment of the contingent liabilities in the resolution plan. other aspect for the negotiation is whether the resolution plan can provide for the waiver of any taxes such as stamp duty, filing fees, etc., payable to any government authority arising out of implementation of the resolution plan. So, key judicial decisions here is the Ghanshyam Mishra Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited, SR Steel India Limited versus Satish Kumar Gupta, Ultratech Nathdwara Cement Limited versus Union of India. The question of whether a resolution plan under the IBC can provide for the waiver of taxes such as stamp duty, filing fees payable to government authorities has been addressed through various judicial interpretations and the statutory provisions. Section 138 of the IBC provides that the provision of the IBC shall have an overriding effect over other laws in case of any inconsistencies. This means that the IBC provision take precedence over other conflicting statutory requirements. Section 31 of the IBC provides that once a resolution plan is approved by the NCLT, it is binding on all the stakeholders, including government authorities, and all claims and dues must be resolved in accordance with this plan. We are taking these decisions one by one. Firstly, we are taking Ghanshyam Mishra Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited. The summary of the case is that Supreme Court held that once a resolution plan is approved by the NCLT, all claims including statutory dues taxes stands extinguished unless specifically provided for in the resolution plan. This ruling emphasized that an approved resolution plan overrides all other claims and dues, ensuring a clean slate for the city. The impact of this decision is that this decision supports the argument that the approved resolution plan can provide for the waiver of statutory dues, including taxes, provided it is explicitly mentioned and approved by the NCLT. The second case, SR Steel India Limited versus Satish Kumar Gupta. It was decided by Honorable Supreme Court in 2019. Summary of this case is that Supreme Court affirms the primacy of the COC in deciding the terms of the resolution plan, including the treatment of the statutory dues. The court held that once the resolution plan is approved, it is binding on all the stakeholders. This has been reinforces the view that the statutory dues, including taxes, can be waived off if included in the resolution plan and approved by the NCLT. Then Ultratech Nandwara Cement Limited versus Union of India. It was decided by the Rajasthan High Court in 2019. The summary of this case is that Rajasthan High Court held that the stamp duty cannot be waived under a resolution plan approved by the NCLT as it is a sovereign function and statutory obligation. This decision highlights the limitation in waiving the certain statutory dues like stamp duty, suggesting that while some statutory dues can be extinguished through an approved resolution plan, other like stamp duty may be still payable unless specifically exempted by the law. Therefore, it is very important that whatever liabilities, contingent liabilities, we want the waivers or the exemptions, we should specifically mention in the resolution plan. The resolution applicant should explicitly include provisions for the waiver of taxes and statutory dues in their resolution plan. This inclusion should detail the nature and extent of waiver sought. The resolution plan, including any provisions for the waiver of taxes, must be approved by the COC and subsequently by the NCLT. Once it is approved, it becomes binding on all the stakeholders, including government authorities and all the stakeholders. it is seen in this case of Ultratech Nandwara Cement Limited. While the IBC provides for the overriding effect of the approved resolution plan, certain statutes, particularly those that are sovereign function like stamp duty, may not be easily waived without specific legislative provisions of the government discretion. We can conclude by these cases that an approved resolution plan under the IBC can provide for the waiver of certain taxes and associated duties payable to government authorities, provided these waivers of certain taxes and associated duties payable to government authorities, provided these waivers are explicitly mentioned in the plan and approved by the NCLT. How the waiver of taxes such as a stamp duty may face legal challenges due to their nature as sovereign function. Thus, while many statutory duties can be addressed within the resolution plan, the waiver of all type of taxes may not be absolute and could depend on the specific legislative or judicial clarification. So third point we are taking is whether the resolution plan can provide for the extinguishment of pending or threatening litigation proceeding, inquiries, etc. The treatment of pending or threatening litigations, proceedings and inquiries in a resolution plan under the IBC has been the subject of judicial scrutiny. IBC aims to provide a comprehensive resolution for the revival of the CD, which includes addressing existing and potential legal challenges. In the case of the COC of the Aducom Solution Limited versus Aducom Infrastructure and School Management Limited, decided by the NCLAT in 2021, wherein the NCLAT held that once a resolution plan is approved, all the pending or threatened litigation and proceedings against the CD are extinguished unless specifically provided for in the resolution plan. This decision aligns with the principle that the approved resolution plan provides for a holistic solution for the revival of the corporate debtor. The impact is the decision affirms that the extinguishment of ongoing and potential legal action can be included in the resolution plan. The resolution applicant should ensure that their resolution plan explicitly address the treatment of all pending and threatened litigations, proceedings and inquiries, which they may get from the information memorandum as provided by the resolution professional. The plan should clearly outline which claims are extinguished and which, if any, are to be resolved separately. Once the plan is approved, then the provisions provided in the resolution plan, like the extinguishment of legal action, if approved by the COC and the NCLT, it will become binding on the stakeholders and all the government authorities. We can say that based on these statutory provisions, judicial decisions, a resolution plan under the IBC can indeed provide for the extinguishment of pending or threatened litigations, proceedings, and inquiries. This is contingent on the explicit inclusion of such provisions in the resolution plan and approval of the plan by the COC and the NCLT. The overriding effect of the IBC ensures that once the plan is approved, it binds all the stakeholders and extinguishes all specified claims, thus facilitating a revival of the CD without the burden of ongoing or potential legal challenges. Next point can be, sir, whether the resolution plan can provide that no new inquiries, litigation, investigation, suits, claim, etc. can be initiated against the CD. Here also, if the applicant wants that no new inquiries or the litigation investigations can be initiated against the CD after the approval of resolution plan, the applicant should explicitly include provisions that prohibits the inquiries, litigations, investigations, suits or claims against the CD in the resolution plan. They should be clearly articulated to ensure there is no ambiguity. The resolution plan, including any prohibiting clauses or new legal action, must be approved by the COC and subsequently by the NCLT. And once this resolution plan approves by the NCLT and the COC, it becomes binding on all the stakeholders. Only thing a resolution applicant has to keep in mind that all the waivers they are seeking must be specific after the provision of to avoid any future dispute and ensure the smooth implementation. In the matter of the Ghanshyam Mishra SR Steel, which we already discussed, and the Agicom Solutions affirm this principle that an approved resolution plan can include clauses to prevent the initiation of new legal actions, providing certainty and fresh start for the CD. So this is a very important question. It is whether the resolution applicant under the resolution plan can seek immunity on non-compliance with the applicable laws. As I said, that sometimes it is not possible for the applicant to comply with all the laws after the taking of the CD because of the documentation or the records of the CD is not available with the successful resolution applicant. In those cases, applicant may seek immunity from non-compliance with the applicable laws in the resolution plan. But applicant always has to make an explicit inclusion of such provisions in the resolution plan, and if it is approved by the COC and the NCLT, then it becomes the binding on all the stakeholders. This principle has been affirmed by the Ghanshyam Mishra case, SR Steel case, and the ArcelorMittal case. So we have to take care that we make the specific provisions of all the waivers, exemptions, and all the immunities in the resolution plan. So, next point is, sir, whether the resolution plan can provide that directors, managerial personnel appointed by the resolution applicant shall not be liable for any past non-compliance by the SOL management of the CD. So under the IBC, particularly as per the section 32A generated by the Amendment Act 2019, resolution applicant can propose in the resolution plan that directors and managerial personnel appointed by them will not be held liable for any past non-compliances of the S12 management of the CD. This provision aims to provide a clean slate to the new management appointed through a resolution process, shielding them from the legal action related to the previous management decisions and actions. It is important to note that the provision is subject to certain conditions and exceptions as specified under the law and judicial interpretations. The intent is to facilitate smoother takeovers and transitions without the burden of the past liabilities, thereby encouraging more robust participation in the resolution process. However, the specifies of how this provision is applied can vary based on the individual case and the terms laid out in the particular resolution plan submitted. So main thing we are seeing, sir, that if we want the waivers, we have to specifically mention in the resolution plan that we are seeking these waivers. If the court and if the NCLT don't have any observations on those waivers and they approve the resolution plan as it is, then those waivers will be granted, and you can avail the benefit of those waivers and exemptions. But we only have to keep in mind that we have to mention all these waivers, exemptions in the resolution plan. Next point is, sir, whether the resolution plan can provide the following clause. If this resolution, if the applicant provides this clause that if this resolution plan cannot be implemented for any reason not attributable to the resolution applicant, then the resolution applicant shall have no liability on this account. If the resolution applicant has issued any guarantees, then such guarantees shall not be invoked on this account and shall be returned forthwith to the resolution applicant. So I face such a situation in one of my cases when the PRA mentions in the resolution plan that if some licenses or the approvals not granted by the authorities, then he will not be liable for the non-compliance of the resolution plan. So I've taken the legal opinions and consulted with many professionals, and they opined that this is a condition. This is a conditional plan, and I think it should not be. It cannot be implemented because it becomes a contingent upon the getting the licenses approvals from the resolution applicant, and that is before the NCLT for the approval of the resolution plan now. But if such conditions comes, then it has to be independently decided by the RP that it is after this condition whether the plan will be implementable or not implementable. Well, then I think they may place it before the COC, or they may take the approval of the COC that as per the RP, this is the condition in the resolution plan and it can be decided by the COC. The resolution plan under the IBC can include a similar clause. Such a clause is often referred to as the force majeure implementation risk clause, which seeks to protect the resolution applicant from the liabilities arising if the implementation of the plan fails due to reason beyond their control, which should not be applicable on existing challenges, including the renewal of licenses. If this condition is such that the resolution applicant cannot foresee that condition or the then this can be affected. This can be affected by the resolution professional, and the maybe resolution applicant may not be liable. But if it is foreseeable, any licenses to be taken, anything to be done, then it will be the liability. The liability will remain on the resolution applicant to implement the resolution plan, and then they cannot get away from the liabilities for non-implementation of the resolution plan. Implementation, if it absolves the resolution applicant from the liabilities of the resolution plan, if it absolves the resolution applicant from liabilities, if the resolution plan cannot be implemented for reasons not attributable to them. This could include regulatory changes unforeseen economic conditions or any other factors that prevent the successful execution of the plan. If the resolution applicant has issued guarantees as part of the plan, as these guarantees are contingent upon the successful implementation, this clause specifies that such guarantee shall not be invoked if the plan fails due to the reason beyond the applicant control. It further mandates that any guarantee provided should be returned to the resolution applicant promptly in such circumstances.
So is there any case law for this?
Sir, there is no case law for this. I not find any case law for this, but practical situations come under this point, sir.
But under which regulation this is allowed? I mean, is it allowed as per the code?
So there is regulation 31.2, I think, section 31.2, which
Okay.
says that it is a duty of the NCLT adjudicating authority to see that plan is implementable. If the condition is such that NCLT feels that this plan is not implementable, they may reject the resolution plan. But if it is implementable, it depends on that if the resolution applicant can foresee that contingent liabilities of the licenses to be taken while implementing the resolution plan.
Okay, thank you.
So if there is some clause like this and it is placed before the committee of creditors and approved by the committee of creditors, and applicant fails to implement the plan because of any unforeseen situations, like we mentioned, unforeseen economic condition or any regulatory changes, then RP may not invoke the performance security and they may return the performance security. And I checked, but I not found any cases when this situation has arisen. Next point is whether the resolution plan can provide severability clause negotiation of resolution plan. The resolution plan may provide a severability clause in the resolution plan, which is normally common and advisable. It should be there in the resolution plan. The severability clause ensures that if any part of the resolution plan is found to be invalid or unenforceable, the remainder of the plan remains in effect. This clause helps to safeguard the overall integrity and enforceability of the resolution plan, even if certain provisions are challenged or deemed unenforceable for any reason. So we can provide for the severability clause in the resolution plan. It is normally there in the resolution plans. Next point is whether the NCLT NCLAT has a jurisdiction to amend the resolution plan, which has been approved by the COC. The jurisdiction of the NCLT or the NCLAT to amend a resolution plan that has been approved by the COC under the IBC is very limited. Once a resolution plan is approved by the COC, it represents a collective decision of the creditors and is binding on all the stakeholders subject to the approval of the NCLT. NCLT role is to ensure that the resolution plan complies with the requirement of the IBC and does not contravene any other applicable laws. NCLT may approve the plan if it meets these criteria and if it believes that the plan offers the best possible solution for the reviving the CD and maximizing the creditors' recovery. After the approval of the COC and subsequent approval by the NCLT, the resolution plan cannot be amended by the NCLT or the NCLAT unless there are exceptional circumstances. These circumstances might include correction of clerical errors, compliances with the NCLT directions, rectification of any non-compliances noticed during the approval process. In one of my cases, I was the chairperson of the monitoring committee. So there were some operational creditors. So SRA has paid to the operational creditors by way of check. They send the checks to all the operational creditors. And there are some non-compliances with, there are some delay with respect to the shares of the corporate shares of the promoters of the CD were freezed by the SEBI. They had given an application with the SEBI for defreezing of the shares so that the shares may be transferred to the nominees of the SRA. So they had filed the application before the NCLT that because of these reasons, there is a delay in the implementation of the resolution plan. Since I was there as a chairperson, therefore I know that NCLT says that they don't have any jurisdiction or the authority to amend the resolution plan. Normally, NCLT or NCLAT don't interfere with the resolution plan which is approved by the Committee of Creditors. The next point is profit during CRP, should it be distributed amongst the COC members or retained with the CD? It was decided in the famous case of the SR Steel. And the Orchid Pharma Limited. Based on these decisions, it says that the treatment of this profit is guided by the provisions of the code and decisions of the Committee of Creditors. RP has the charge of managing the operations of the CD during CRP. Any profit earned from the ongoing operation or assets of the CD are typically managed and controlled by the RP. If some revenues are coming during the CRP time, then RP has a source of the funds and they may use it for the CRP expenses. But if there is any surplus left from the revenue earned by the CD from the assets of the CD, then COC may decide how to distribute or to the stakeholders. The decision regarding whether these profits should be distributed among the COC members or retained with the CD depends on several factors. If the resolution plan is being formulated, profit may be retained to enhance the value of the CD or to facilitate a smoother operation until the finalization of the plan. As the primary object of the CRP is to maximize the value of the assets of the CD for the benefit of the creditors. Therefore, COC may decide to retain profit to strengthen the financial position of the debtors or to improve its operational capabilities. In the SR Steel resolution which was a landmark case under the IBC, where the treatment of profit and asset during CRP played a significant role in the resolution process, and where the Supreme Court has decided how this profit will be distributed. So this is basically the COC which has to decide how the profit earned or the revenue earned during the CRP process will be distributed amongst the stakeholders, or it will go to the SRA. Next point is whether the resolution plan value can be less than the liquidation value. So, as per the IBC, resolution plan value must be equal to or higher than the liquidation value of the CD. There are many judgments on this which we have not mentioned here, but the principle of this that the resolution plan value must be higher than the liquidation plan value is that if the resolution plan must be evaluated to ensure that it offers a better outcome than the liquidation. Liquidation value is typically determined through a valuation process and represents the estimated amount of that could be realized if the assets of the CD were to be liquidated. The COC evaluates and approves the resolution plan based on the various criteria, including whether the plan offers a higher value proposition compared to the liquidation. This is crucial in determining the viability and the feasibility of the resolution plan. Section 30, subsection 2 of the IBC specifies that the resolution plan should provide for the payment of debts of the operational creditors in such a manner which should not be less than amount to be paid to the operational creditors in the events of liquidation of the CD. But I think it is not mandatory in some cases where they are very less asset. Resolution plan, this plan value can be less than the liquidation value also. I think it is not mandatory. If anyone has any experience on this, next point is, sir, whether the claimant who have not filed their claims in CRP lose the right to seek the recovery after approval of the resolution plan. Now, after amendment of regulation 13 of the CRP regulations 13 1A, 1B, 1C, they have increased the time for submitting the claims from 90 days to the date of the issuance of the RFRP, which is T plus 105 days, by providing the reason for delays. So regulations has increased the time for submission of resolution plan, but even after this increase, if some stakeholders fail to file their claim, whether he has a right to seek recovery after the approval of resolution plan. I think the post approval of resolution plan, we have discussed that the resolution plan cannot be amended. Therefore, the resolution applicant will only consider the liabilities as provided by the resolution professional in the information memorandum. If the resolution applicant has not provided for the liabilities, because it is not provided by the resolution professional, and if the claims received late after the approval of resolution plan by the honorable NCLT, then I think he cannot seek recovery of his claim amount. In the matter of the Puneet Kaur versus KB Developers Private Limited, decided by the NCLAT in 2022, held that in terms of regulation 36(2) of the CRP regulations, obliges the RP to include assets and liability of the CD, and also the liability towards those home buyers who have not filed their claims, and is required to be included in the information memorandum. The information memorandum on the basis of which resolution plan is made includes all assets liability of the CD, all of which shall be appropriately dealt with within the resolution plan. Since non-consideration of the claims will lead to unfair resolution, it was also held that the payment have been received by the CD and allotment letters have been issued to the home buyers, then the liabilities towards the home buyer cannot be wished away only because there was a delay in filing the claim before the resolution profession. But in the KB developers case, they are talking before the approval of resolution plan by the honorable NCLT. In this order also they are saying that in a later judgment of Miss Mehta or something, which has relied on this case of the Puneet Kaur, says that the belated claim of the home buyers have to be accepted even after the approval of the resolution plan by the COC. However, the claims received after the approval of the resolution plan by the honorable NCLT, the claims cannot be entertained by the either by the resolution applicant or there is no COC after the approval of the resolution plan. Therefore, any claim received after the approval of the resolution plan by the Honorable NCLT, I think those claimants cannot seek the recovery of their claims.
And what about the claims which received after the RFRP but before approval of the resolution plan?
Those claims are the claims received after the RFRP, but before the approval of resolution plan, they have only one remedy to file application before the Honorable NCLT for the condonation of the delay of the filing the claim. If the NCLT condones the delay, then they may ask the RP to verify the claim and accordingly admit the claim and ask the RA to take care of those claims.
So as a RP, it's mandatory that we have to inform the prospective PRAs about such claims.
Yes. After the approval of this resolution plan by the COC, if
No,
such
before.
cases comes, if yes, before. After the approval of the COC and before the approval by the NCLT, if some such claims comes, or after the RFRP issuance date, if such claims come, then it is the duty of the RP because RP has to reject those claims. It is after the limitation period. If the RP rejects those claims, then the claimants may go to the NCLT for the condonation of delay of the claim.
Right.
And if the NCLT passes such orders that they condone the delay and they may direct the RP to verify the claims, and the RP verifies the claim and found it to be admit those claims, then it will be the duty of the RP to inform the RA about those orders and that he has admitted those claims, so that they may include these claimants also in the resolution plan.
Okay, but it doesn't have to inform that such claims have been raised, although they are not yet approved by NCLT. Does he have to inform that?
Because it is not binding on the resolution profession. I think only after the condonation delay by the NCLT, RP duties comes into play. Then only he can verify the claim because he has already rejected the claim. There is no legal validity of those claims in the eyes of the resolution profession. But once the direction comes from the NCLT to verify the claim, he can verify the claim and then he can inform the RA about those claims, so that those claims can be included in his resolution plan.
Thank you.
So next point is how far the resolution plan can be considered as fair to all stakeholders when there is a difference in the ratio of unsecured financial creditors and creditors. We already discussed that the COC has the authority to decide how much to distribute to which stakeholders. Court have held that while financial creditors and operational creditors can be treated differently due to their distinct roles and priorities, the treatment should be justifiable and reasonable. Any significant disparity in the treatment of the different classes of creditors must be supported by valid reasons and must be in compliance with the statutory provisions. So as we discussed in the beginning that there may be a differential treatment even to the same class of the creditors. Like I had given the example of the secured creditors. If the security value is higher for one creditor and it is less for the other creditor, then he may give the differential treatment to the secured creditors also. But there should be justification for the differential treatment. So this is the purely a commercial wisdom of the committee of creditors, and they may allow the resolution plan which has the differential treatment for different stakeholders. Next point is, can a resolution plan provide differential allocation of amount to be paid to current employees and ex-employees or keeping sizable outstanding? A resolution plan can provide for a differential allocation of amount to be paid to current employee and ex-employees or establish thresholds for outstanding amounts under certain conditions. Firstly, as we discussed that this is the commercial wisdom of the COC, they may allow the differential treatment to same class of stakeholder. If the SRA wants to retain some employees, they may pay more amount to the existing the employees to whom they are retaining, and they may pay less amount to the employees to whom they are not retaining. So this is the commercial wisdom of the committee of creditors to approve such plans, which gives a differential treatment. But it should be fair and equitable treatment, and it should be reasonable while the applicant is giving the differential treatment to the stakeholders. However, it has to be seen by the resolution applicant that because employees are also the operational creditors, they should not get the less amount what is provided in section 30 subsection 2 of the IBC. They may give the justification like they are retaining the critical talent for the city to keep it as a going concern, and the employees they are retaining will be useful for the city and for promoting, for growing the city, growing the businesses of the city. They may give any justification. Again, sir, we are on the point whether can the resolution plan be proposed as conditional. So we already discussed whether plan can be conditional. Plan can be conditional subject to it will remain implementable if by some conditions. If the resolution plan is not implementable, then an honorable NCLT may reject the resolution plan on that basis. So that's all for today's this conference. If anyone has any question, they may ask the question. If you have put in the chat box, then you can see in the chat box. So we can discuss any aspect of this conference. If you want to, if you have any queries or if you have any experience, you can share. If you don't have anything to share, then we may proceed with some more situations for the resolution plan, because our time is till 3 p.m. Oh, sorry, 5 p.m. 15 minutes left. One condition, important condition, may be that whether waiver from compliances with the provisions of companies can be asked for. If a applicant, like I had given the example of one of my cases, the audited balance sheet is only till 2015 and we don't have the books of account. How to make the balance sheet after the approval of resolution plan? It is now pending before the Honorable NCLT. How will comply with the provisions of the Companies Act? So can we seek waiver for the provisions of the Companies Act that we will not file the balance sheet till this date, or we will make the balance sheet of current year on the basis of only the last audited balance sheet? So can we give these kinds of waivers or exemptions from the in the resolution plan? I think we can ask for the such waivers, but it is to see that how it will be implemented, because the balance sheet cannot be made. Balance sheet is normally made out of from the last balance sheet. There is opening balance, closing balance. If we don't have the closing balance, how will take the opening balance? There is many practical problems in complying with the provisions of the Companies Act. But however, we can seek such waivers from the in the resolution plan. One question can arise whether the resolution plan can provide for that the resolution applicant will not be liable for subsidiary companies associate company of the corporate debtor. Say some in the real estate sector, normally the land owning companies are the wholly owned subsidiary company or the subsidiary companies. So whether the liabilities of those subsidiary companies will come to the resolution applicant, this is a very important question, because the applicant resolution professional has provided the information only with respect to the holding company, not with respect to the subsidiary companies. RA is not knowing what are the liabilities of the subsidiary companies. Therefore, he cannot provide the treatment of the liabilities of the subsidiary companies. But question arises that licenses for the project may be taken in the name of the land owned by the subsidiary companies. If he is taking the ownership of the land, then how he can avoid the liabilities of the subsidiary companies? I think the practical answer for this is maybe that if the SRA takes over this company, a corporate debtor which has the wholly owned subsidiary or the subsidiary companies, then after the approval of the resolution plan, he become the controller or the majority shareholder of the subsidiary companies. He can control the assets of the CD, and directly or indirectly he will be liable for the liabilities of the subsidiary companies also. Other question may arise about the resolution plan is that whether the how to absolve the CD resolution applicant with the liabilities losses of the subsidiary companies. Applicant may specifically mention in the resolution plan that he will not be liable for the liabilities or losses of the subsidiary companies. As I said, that if the other company is a subsidiary company or the wholly owned subsidiary company, he become ultimately the owner of the subsidiary companies, and all the liabilities, he cannot ignore the liabilities of the wholly owned subsidiary company or the subsidiary companies. So it is a practical situation, and not it has to be seen how to work in these situations. But I think if the SRA is taking the assets of the subsidiary companies, then he cannot take the waivers from the liabilities of the subsidiary companies. Their question may arise that in the subsidiary companies also, subsidiary company may had borrowed some loan and secured their assets of the immovable properties. Then the SRA, if he has to utilize the immovable properties of the subsidiary company, then he has to discharge the securities of the subsidiary companies. And during the COC meetings, what rights the STOL directors has in the COC? considering the fact that they do not have the voting rights. As well, directors, because as per the provisions of the code, we have to give notice of every COC meeting to the as well COC members, and also of the COC meeting wherein we are discussing the resolution plan. They have all the rights. We have to provide the copy of the resolution plan to the directors of the COC, and they may object the resolution plan also in the NCLT. But they have the right to participate in the COC meeting wherein the resolution plan is being discussed, and they may ask the resolution professional to provide a copy of the resolution plan, and on that basis they may file objections against the resolution plan. In one of my cases, both the directors of the CD were expired. Now one immediate relative of the CD wants to see copy of the resolution plan. So he had mailed me that he wants a copy of the resolution plan. I rejected to provide a copy of the resolution plan because he is not director of the CD. And he has filed application before the Honorable NCLT. In that application, the arguments has been completed. His application, he said that he is the guarantor of the CD. Therefore, he needs a copy of the resolution plan. We said that if he is a guarantor of the guarantor for this given guarantee on behalf of the CD, then we may provide a copy of the extracts of the part when the resolution plan is dealing with the guarantors, and the plan is this application is pending before the Honorable NCLT. It will be decided soon. So such situation may also arise. There's many complicated cases with respect to SFIO, how the funds recovered pursuant to proceedings and by the SFIO to be dealt with. These are the complex situations which RA or the RP has to deal with. I think we had concluded with this webinar. Anyone from the ICSC side? Anjali ma'am? Sir, if anyone has any queries, they can ask the queries.
Sir, I think there are no queries.
Yes. Then ma'am, we can conclude this conference.
Sure, sir. Thank you very much, sir, for giving such a nice session, for sharing your knowledge with us. Thank you very much. Sir, you are requested to please share the PPT for the session.
Sure, ma'am. And thankful for giving me opportunity to give this webinar, and to all my colleagues here who are listening carefully. Thank you all. Thank you very much, sir.
Thank you.
Thanks, sir. Thanks.